Good afternoon, everyone. Thank you for coming. We have I believe 3 cases on the docket. The last case was continued. So remember, when you come up, please, after you state your name, let us know if you wish to reserve any time for rebuttal. Remember that these proceedings are live streamed. So whatever you say goes out there, and you can't pull it back. So keep that in mind as you're giving your presentation. Unless there are any announcements, and seeing none, would you please call the first case?
Milcrofton Utility District of Williamson County, Tennessee versus Non-Potable Well Water, Inc.
Good afternoon, Your Honors. May it please the Court, Will Holloway, the Williamson County Bar, on behalf of Milcrofton. If I could reserve 5 minutes for rebuttal.
5 minutes, okay.
Yes, Your Honor. Thank you, Your Honors, for hearing us this afternoon. This case concerns the exciting world of water utility rights under the law created in 1937. It is an area of the law that I think, based on my research, this court doesn't deal with on a daily basis. But I will say, once one gets their bearings around what this law does, this particular case is very straightforward. There are several important and material facts that Milcrofton would submit really decides this case. The first being that Milcrofton is a utility district created under the Utility District Law of 1937. That is not in dispute. The second is that as a result of being a utility district, Milcrofton has exclusive rights to service water to residents within its exclusive service area. Again, not in dispute. The Kings Chapel subdivision is a subdivision that is within Milcrofton's exclusive service area. Not in dispute. Milcrofton provides water services for drinking, showering inside the home, washing your car, irrigation, every purpose for its exclusive service area, including within the Kings Chapel subdivision. Not in dispute. Non-Potable, the appellee, is a for-profit corporation that is owned by a gentleman named Mr. John Powell.
Now, they just maintain the water pump, right? They maintain it, they repair it, they repair a line if a line needs repairing, but they don't own the water, right?
They do not own the water. And the land where the well is located is actually owned by a lender to the developer. So the lender to the developer, and I'm not sure if the record actually reveals the name of that lender, but the lender to the developer owns the land where the well is. And
so if you get an injunction against Non-Potable Well Water, Inc., and they can't do what they do anymore, couldn't the HOA just go out and hire somebody else just like them and do it?
It's a fair question.
Thank you.
When the case started, Non-Potable's answer said, yes, we provide the water services. Yes, we own the well. That's in their answer multiple times. Answered written discovery and said,
own the well?
That's what they said in their answer.
Okay.
Answered written discovery and said, yes, we provide the water services to customers. At the time the case started, it was 30 customers. At the time the trial happened, it was 17. Yes, we generate revenue from that, and we've generated approximately $19,000 in revenue from it. Depositions were taken, and these are all cited in our brief. Depositions were taken. Non-Potable again said, yes, we provide the water services. Yes, we do that. Trial comes, and there's the shift to the HOA does this, and we are there to facilitate and maintain the pump. So in Milcrofton's defense, they went through the whole case with Non-Potable saying they were the ones doing this. What's Also in the trial is that after Non-Potable made that point, there is a lengthy cross-examination on it where Milcrofton confronted Non-Potable and said, yeah, but what about your answer and your interrogatories and the depositions? And then ultimately, the ultimate question was asked on cross-examination. Look, do you provide water services to these 17 customers or not? And Non-Potable said yes. And that's cited in our brief, that Non-Potable is providing water services. Maybe more directly to Your Honor's question would be, what exactly are you trying to do? Why are you filing this injunction against Non-Potable? And really, I think that goes to the nature of the injunction. We Milcrofton, wishes to restrain and enjoin the act of providing these water services. To that end, it really is irrelevant who owns the land, who authorizes Non-Potable to do what it does. Non-Potable is, in Milcrofton's respectful opinion, violating the law by providing water services within Milcrofton's exclusive service area. That is the basis of it.
Thank you.
Yes, Your Honor, thank you. The trial court bases its opinion, and if Your Honors will see in the conclusions of law section in the trial court's memorandum, it really begins its analysis, and it says that Non-Potable, the legal question is whether Non-Potable is a public utility. And the memorandum states,
Counsel, did
Yes,
you
Your Honor.
argue before the trial court that that wasn't required, that you didn't have to show that they were a public utility?
yes, Your Honor, and in our reply brief, because that was raised in the response brief, in our reply brief we showed two different arguments made by Milcrofton's attorney at the trial, arguing that 782-301 is different than Title 65 and you don't have to prove a public utility. And that's very clearly laid out in that argument in the reply brief.
There's language in 782-301A1B that talks about to furnish those services. Am I correct in understanding those services that we're talking about in 782-301A1B as being the statement of services that's provided under 782-201A1? Is that, I'm trying to figure out what those services are in reference to that statute. Is that does that relate back to the statement of services that the utility has to provide? Because I didn't see a clear definition of what the services are in the statute. Does that relate to that statement of services?
Under the Utility District Law of 1937, 782-101 et sec, that is the statute that governs the creation of these entities and when, my understanding, and I'm not sure if this is in the record, but my understanding is Milcrofton applies and is awarded its exclusive service area, which it has done and was undisputed that it has this. So the services that would be provided in that situation would be water.
Has there been any contestation about whether these services, in terms of providing water for purposes of irrigation, for watering your yard, is within the scope of the services that we're talking about under 782-301A1B? Has there been any dispute about that, or has that been essentially conceded and this is fought out on other grounds?
There was a stipulation that Milcrofton is the exclusive water service provider.
And that this service is part of this, is within the realm of the services that are being provided?
There was testimony that Milcrofton provides irrigation services.
Okay.
It was conceded by Non-Potable on cross-examination that but for Non-Potable providing this, Milcrofton would be providing it. And Milcrofton testified that they provide this to other residents within the Kings Chapel subdivision. So the trial court's ruling, Your Honors, really focuses on this definition of a public utility. And the trial court states that Non-Potable is correct in stating this court must find it to be a public utility as defined by 65-4-101 to expose it to any potential liability under 782-301. And that's really the crux of this appeal, is that sentence. And stated another way, does 782-301 only protect Milcrofton against competition from other public utilities? And as I mentioned, the facts were pretty basic and straightforward. I also submit this case can be decided just on the face of 782-301. 782-301 states, in pertinent part, that so long as the district being Milcrofton, continues to furnish services that is authorized to furnish in this chapter, the service being water, the district is the sole public corporation empowered to furnish those services in the district, and another person, firm, or corporation shall not furnish or attempt to furnish those services. Nowhere in that statute does it mention no other public utility. The language is very, very broad. Person, firm, or corporation. And so Milcrofton submits.
Counsel, does that mean if I have a well on my property, just me, I have a well on my property, that I am in violation of this statutory provision if I draw water from that well as an individual?
To use on your own land?
To use on my own
No,
land?
Your Honor. Furnishing the services would be furnishing the services to another.
Okay.
And one of the arguments that is mentioned is this argument about HOA riparian rights in the response brief that touches on that a little bit. First, the riparian rights, and this is cited in our brief, apply to the owner of land using that water for their own lawful purpose. The HOA doesn't own this land, so the riparian rights aren't triggered. And the HOA is not using the water. The water is being distributed to 17 individual homeowners that use it on their privately owned land.
So the HOA doesn't own the land, the bank does?
Yes, Your Honor.
Okay, if that ever gets paid off and the HOA owns the land, at least the land that is common areas, and the well is in a common area, would they be able to furnish?
I don't believe they'd be able to furnish services, no, Your Honor.
Because they'd still have to use somebody to pump it, and
Well,
that person would be in trouble with
Because
you?
the act of distributing to customers is the violation. Now, if the HOA, to Your Honor's earlier point, if the HOA were to pump the water and were to use it only on the area that they own, that'd be a very, very different case. But when you're supplying it to customers.
That's the case of the golf courses.
Correct, Your Honor, and that was a specific application, but yes, Your Honor, that was a specific example of that. They were using it for their own purpose.
Okay, so it could be used, what if it was part of your HOA fees that you pay every month or every 6 months or every year to have access to this water? Would that change it?
I don't believe so. Title 65 talks about an HOA's ability to supply water. And what Title 65 actually says, and this is a very, very, very specific provision for HOAs only, but what it says is that an HOA can do that only if it is not being provided by the exclusive service provider.
Okay,
And when I come back for rebuttal, I'll give Your Honors that specific statute. Thank you.
I've got it. Thank you.
Please the court, counsel, I'm Philip Jones, the Nashville Bar. And current counsel for the appellant is a fine gentleman and a fine lawyer, but he differs from me in this sense. His firm is the third firm that the appellant has retained in this matter, and he actually was not involved at the trial. This case has had 5 stages going back 8 years, and I've been involved in all 5 of those stages. So I want to address some points that you raised in your questions, and then I'd also like to dovetail that into 3 areas of focus that I'll sort of departmentalize. One is a short procedural history, because I think it's relevant to the positions that the appellant now takes versus positions they've taken at various other levels, including their earlier appeal, which Judge Bennett was involved in. Secondly, touch on some key facts that really dovetail into some of your questions. And third, I want to address the applicable statutes, which you have addressed. By way of history, briefly, this started with the Tennessee Public Utility Commission. Milcrofton filed an action against my client, including the primary shareholder of that entity, claiming that my client was a public utility, and only claiming that. That was dismissed. They have a statutory right to appeal it directly to this court for reasons I'm not sure they did not do that. They waited 7 months and filed an action in Chancery Court for Davidson County, again alleging that my client was a public utility and only alleging that. The Chancery Court for Davidson County dismissed that, and they appealed it to this court. We'll call that Milcrofton Appeal Number 1. Judge Bennett was involved in that. This court affirmed that prior dismissal. Then they filed the current action in the Circuit Court for Williamson County, and they asserted 3 claims. We litigated all 3 claims, and we prevailed on all 3 claims. And those claims were as follows: a statutory claim for violating the utility statute, where they saw injunctive relief, which Judge Bennett addressed, but they also sought pretty extensive damages in the hundreds of thousands of dollars. Also a common law claim for unfair competition, also a common law claim for nuisance. On this appeal, their second appeal, if you'll note from their briefs, they are not appealing the trial judge's dismissal of those common law claims, only this statutory claim. So that is what brings us here today on their second appeal, which is stage 5 of their litigation. And I want to highlight some key facts which dovetailed into what some of Judge Bennett's questions. And these really are not disputed. If you note from their brief, they really don't argue that the judge made any erroneous rulings as to the facts. In fact, Exhibit 23 was a stipulation of facts. Exhibit 24 was a transcript of those stipulations of facts, and I had it transcribed rapidly and filed that as well because I didn't want there to be any confusion on the scope of that stipulation. But I want to hit on 10 or 11 key facts. 1, the land that this well is on, whether owned by a lender, it is not disputed. It is controlled by the HOA. It is not controlled by non-potable water and never has been.
Is Non-Potable providing water services here, though? And are they pumping the water, or are they?
They perform maintenance on a pump owned by the HOA, and they perform maintenance on lines owned by the HOA. And those are the only services, and while it is a for-profit entity, it has not billed for those services in, I think, 8 years, and it only billed back then for cost, not profits. Third, the electricity that operates this pump is paid on a utility bill billed to the HOA, not my client. So my client doesn't own or control the land, own or control the pump, or pay to operate the pump. The appellant's water lines are in the utility easement in front of the homeowner's property. The HOA's water lines are in the area behind each of the homes in land designated on the plat plan and on each of the deeds as common area. Again, not owned or controlled by my client.
Is your client's business described in the record anywhere? I mean, does he do this for other places? Does he
No.
generally work on electrical equipment? What does he do?
This subdivision is called King's Chapel.
Right.
It was the baby or the brainchild of a man named John Powell. He also owns a company called Superior Waste Systems that operates the sewer system in this development by authority of the Public Utility Commission. As part of that, he also has the real estate, King's Chapel Realty, which sells the houses. These are all, none of these have been even alleged to be non-existent entities. They all have separate bank accounts, file separate tax returns, have separate tax ID numbers. And he set up this entity just to separate it, and primarily because he didn't want to be confused with the sewer services, which are regulated by the Utility Commission.
So it just does this?
Just does this in this subdivision, which has, I think, over 400 lots available to be sold. Over 300 have been sold, and I think council said 30 people were using it. That's not in the record. The most that have ever used this water is 18, and for the last few years it's been 17. And the key thing is, it's only irrigation water, not drinking water.
And the HOA uses it also to irrigate
Yes, in fact,
common areas, right?
council said, and I don't slide him, he wasn't at the trial, he said, otherwise the HOA's not using this water just for these 17, and the evidence was to the contrary. They use this to irrigate the common areas where there's shrubs out front. They use this for the swimming pool. They have a garden on site.
Council, I have a question, sort of, this is redirecting you a little bit here, but the basis of the trial court's ruling is a public utility, 782-301A1B. And I'm looking at 301A1B, I don't see public utility anywhere there. I see another person, firm, or corporation. So where does the requirement in 1B come from that this has to be a public utility? Because it's certainly not in the text of that provision itself.
Well, I think the actual text is helpful because the top of the page, this is part of the Utility District Law of 1937, right there in the statute. And the position that the appellant takes now at stage 5 was an audible. That's not really a position they've previously asserted. Before, it was always, and in fact, this court's appellate opinion says, they claim that non-potable is a utility, and they've lost on that 4 separate times. Now they've done an audible, and they say, well, we don't have to prove they're a public utility because this statute that you're asking has 3 nouns in it. It applies to any person, firm, or corporation. I would submit that's correct. Any individual in here and any entity is a person, firm, or corporation. But those are the nouns in it. It has verbs in it also. And that's 3 different times. It says the furnishing of services. And what services are governed by the Utility Act of 1937? Utility services. So embedded in that, perhaps not expressly, but certainly implicitly, is you're providing utility services. So when they suggest, well, we didn't have to prove they're a public utility. We just have to prove they're a person, firm, or corporation. Yes, that would be who the statute is applicable to. But what is the conduct that's governed by it? And then you have to look at the verbs, and it says furnishing of services. It's not the furnishing of IT services. It's not the furnishing of security service. It's utility services.
Are the services that are being provided here, is that relating to 782-201 and the statement of service or services to be supplied that's supposed to be included in the petition under 782-201A1? Is that the service? Because we're covering multiple types of utilities.
Sure.
Right? So the petition itself is what's going to state what the services are, and then the petition gets approved or doesn't get approved. But those are the services, right? It's the petition that would tell us what the services are. I mean, there's some kind of utility services, but that's what the services would be.
I'll fall on my sword and say I'm not entirely sure of the answer to that.
Okay.
But what I will say is this. We do not have in this case or the prior case an attack on these enforceability and constitutionality of this, that it's vague or ambiguous. I submit a clear and reasonable and almost juvenile interpretation of the Utility Act of 1937 must concern utilities. And that can be water, that can be electric, that can be gas, but this one just happens to concern water.
But isn't that what's being provided here? I mean, you're providing water services in terms of this is water that's being utilized for irrigation purposes, and its uses may be extensive in terms of the HOA's own uses, but it's also being provided onto private property owners' land. And so isn't that water services that are being provided, a utility service?
Well, here's the distinction that I think is very different. They're not providing it to anyone else. They're providing it to homeowners in this property, and each homeowner must be a member of the HOA. So to get from A to Z, the HOA is providing water to the HOA and not any other entities, whereas the appellant provides it to multiple cities, towns, and in fact spreads over multiple counties.
The HOA doesn't own the lots, though, of the private homeowner, right? I mean, the private homeowner owns their own, his or her own lot, and if I'm putting it on my lawn there, that's not the HOA's lawn. That's my lawn.
Well, that's the HOA providing water by consent to the homeowner who is a member of the HOA and who pays dues to that HOA, who then uses that water not just for my lot or your lot, but for the shrubs out front, the garden area, the swimming pool, etc. I think that's the key difference. And I want to skip ahead and dovetail into something else. In their brief, they use the phrase "but for" 7 different times. But for the appellee's conduct, we would be providing water to these 17 infamous homeowners. But that's actually not true. Their own witness, Mr. Michael Jones, conceded on my cross-examination, well, we can force them to buy drinking water from us, but we can't force them to use irrigation water. They could have a desert landscape in their yard requiring no irrigation. They could have a plush lawn and only rely on rain from heaven to irrigate it. And in fact, 2 of the board members testified, I don't use the irrigation water for me, the HOA, or them. So that dovetails into the question on the injunction. They're trying to stop people from doing things that even if you issued an injunction, they don't pick up those 17 clients. Those 17 could say, I don't want to use their water. It's too expensive. I'll rely on the rain. Finally, I want to dovetail in. I can't recall if it was you, Judge Usman, or you, Judge Bennett, the riparian water rights issue. And you raised an excellent point. The testimony at trial was that once these loans are paid off, this land defaults to the HOA by ownership. But there's no dispute that even with the loans, it is controlled and maintained by the HOA. So the HOA is using water from their well to irrigate yards to HOA members who effectively or indirectly own that well. And in their appellate brief, they said, well,
Is it their well? Is the HOA's well right now, or is it the lender's well?
it's the lenders. However, by the deeds which were entered, that area is deemed to be common area, which by the deeds and by the HOA directives is, whether owned or not, is controlled and maintained by the HOA. And one additional point, and this dovetailed into Judge Bennett's question. I've been in this case for 8 years, and I'm still baffled as why they did not sue the HOA. Effectively, by analogy, if I have a franchise that says I get to provide all the swimming pools in this big subdivision, and someone over here puts in their own swimming pool, and they say, well, wait a minute, we've got exclusive statutory franchise rights to put all these pools in. But rather than sue that owner, they sue his pool man and say, you can't take care of his pool. Well, if that would be res judicata in this, it would be a meaningless judicial enforcement because they could hire somebody else to do it, or the HOA could put somebody on salary at W-2 compensation to do it. And I think the fact that they never sued the HOA is very indicative of the position they've taken. In fact, in the first appeal, in this court's opinion, it said that their position and arguments were specious. I think that was a pretty applicable word for the situation here. And then finally, got about 20 seconds left, there was some discussion about Mr. Powell's testimony that in the initial answer they said, well, we own the well and we own the pump. And then at trial he said, well, actually the HOA controls that land, the HOA. That's really a distinction without a difference, because when I was reading their appellate brief, I thought, okay, the facts didn't really go their way, so they just want to attack Mr. Powell. But if you look at the trial court's ruling, he specifically said that he found all the witnesses to be credible. And while your review is de novo, assessments of credibility are not. They are to be given great weight. And on redirect, he clarified all that. Well, yes, at the behoovement of the HOA that operates the pump, and we introduced even the utility bills on the pump as who pays those bills, and all the deeds and all the HOA documents that can indicate who controls that land. You look like you had a question, Judge. All right, I think I've gone over.
It's all right.
Forgive
Thank
me.
you.
Please, the court, if I could, very briefly. My esteemed colleague, who I have a lot of respect for, and I did a phenomenal job trying this case. I do want to touch on what I counted to be 3 items that were raised in my argument or in my brief that were claimed to be incorrect. The first being the number of homeowners. I mentioned that at the starting of the case it was 30. It was claimed that that was nowhere in the record. Paragraph 16 of defendant's answer, defendant began providing irrigation water to a limited number of homeowners for irrigation purposes, parentheses, approximately 30 owners. That's volume 1, TR 11. The second item has to do with something that I mentioned during the argument about non-potable, conceding it provided water services. This is volume 7, 348 question, and this is what I mentioned is at the end of that lengthy cross-examination. So is non-potable providing a water service to customers in King's Chapel, yes or no? Answer, yes. Volume 7, 348. And then the third item is the argument about the pivot and the claim that this argument about 782-301 being all-encompassing as opposed to focused to public utilities, and the claim that this was a shift by Milcrofton. Volume 7, 373 to 374 is Milcrofton's initial closing argument, in which Milcrofton's attorney says, quote, 782-301 does not strictly apply to utilities. I agree 65-4101 is dependent upon that determination, volume 7, 373. Opposing counsel then they made their closing argument, and Milcrofton was permitted rebuttal argument. Rebuttal argument, volume 7, 377. Lawyer says it, referring to 782-301, does not say no other utility. It does not say no other district. It says no other person, firm, or corporation. The language that the legislature used in 782-301 is person, firm, or corporation. They did not choose utility. So non-potable is a corporation furnishing water within Milcrofton's service area. That falls squarely within the interpretation of that statute. And so I submit Milcrofton properly raised this issue and argued this issue before the trial court. The request sought by Milcrofton on the appeal, opposing counsel is correct. The only issues raised on the appeal is Milcrofton is asking for a declaratory judgment, asking this court to order that Milcrofton is the exclusive water service provider within its district, and Milcrofton is asking for an injunction enjoining and restraining non-potable from competing or providing water services within Milcrofton's exclusive service area, including King's Chapel subdivision. And I don't want to wear out my welcome, and I don't want to repeat myself unless your honors want me to, but if there are any questions.
The declaratory judgment that you're seeking here, would that encompass preventing the HOA from providing water services on HOA property? I know today you're saying it's the lender, down the road this is the HOA property here. Does that declaratory judgment keep the HOA from being able to water its common areas?
I wouldn't think so, Your Honor. The same way in your example you could water your own. If an entity or a person is using their own water to water their own land, then Milcrofton's interpretation is that that does not qualify as providing a water service.
Okay, so you're not providing a service because it's not to somebody else, as your understanding of the service word is the key there in terms of what the difference in your view between those two things.
Correct, and in this particular case, sending the water out to 30 or 17 or one customer collecting $19,000 in revenue for doing so certainly applies as providing that water service in direct competition with Milcrofton.
So you're not asking for any lost profits or anything like that?
No, Your Honor, not on. They did raise that at the trial level, but not on the appeal.
Okay. Thank you.
Thank you, Your Honors.
Thanks to you both. We'll issue an opinion in due course. Would you call the next case, please?